To Law and Crime Daily, I'm Jesse Weber. A former game show contestant turned murderer. Well, that's the accusation against an Illinois man who prosecutors say killed his wife, allegedly shooting her 14 times. Police and prosecutors say that Timothy Bleefnick was going through a contentious divorce with his wife Becky when they claim he decided to break into her home and kill her in February of this year. Bleefnick is charged with 2 counts of first-degree murder and a count of home invasion. Prosecution says that Becky told friends she was scared of what the defendant might do to her to get custody of her kids. Bleefnick had the couple's 3 sons at his home the night of the murder and allegedly left them home alone to go commit the crime. The state also says the defendant's search history is quite damning. It apparently includes searches like how to make a homemade silencer, Quincy Police Department response times, using a crowbar to open doors, and even how to wash gunpowder off your hands. Back in 2020, Tim Bleefnick appeared on an episode of Family Feud, and when asked what his biggest mistake was on his wedding night, his response was saying, "I do." That answer is now back in the headlines as Bleefnick goes to trial. Take a listen to part of the opening statements.
The last minutes of Becky Bleefnick's life were not spent surrounded by family, friends, and loved ones. The last minute of Becky's life was not spent in the warm embrace of her 3 children, Deacon, Grayson, and Arnold. The last minutes of Becky's life were not spent in love and compassion and tenderness. No, the last minutes of Becky's life were spent in fear, in pain, in terror. She looked into the eyes of her murderer, her husband, the defendant.
But if you look at the big picture here, folks, the evidence will not show proof beyond a reasonable doubt that Tim committed this crime. They have a great theory. I'll give that to them. The theory is great, the motive is there. I mean, they didn't really look at anybody else in this matter because the motive was so abundant, I guess, in their mind. But one thing we went over yesterday that you all agreed with is that motive is not something that they have to prove to you. Motive is not the element of the offense, and motive is not something that you will be asked to consider in your jury. So what I ask you before we get into this is listen to the evidence, ask yourself, what does it prove, and utilize your common sense.
All right, legal analyst Brian Buckmeyer and Terry Austin are here. Brian, I'll start with you. What are the strongest arguments on both sides that you think are going to ultimately help decide this case?
It's weird, Jesse, but I think for the prosecution, it's the Google searches. I mean, you listed off some of the worst ones, but to add on top of that, it's also the fact that these 2 were separated, that the ex-wife was dating someone else, and supposedly there were Google searches on Timothy's laptop or phone, looking up the license plate of the other lover in her driveway. Yeah, you don't need to prove motive, but it really helps when you're talking about ex-lover and jealousy in terms of a crime like this. But on the other side, I found it very interesting that after Timothy was arrested, they took 6 pairs of his shoes and compared it to that of a footprint just outside the window of where the person broke in and couldn't find a match. Both facts, I think, helped either side pretty well.
So, Terry, I want to talk about the Family Feud video. Went absolutely viral, but do you think it's actually going to be used or ever be used against him during a trial?
I don't think it's going to ever get into the trial because it's not really relevant. First of all, I think he was joking. It's not going to really show his motive. If he said something like, first thing I want to do is kill my wife, well, then I think they might say there's some probative value and less prejudicial value. But here he's joking, so I don't think they're going to let anything like that in. But what it could do at the end of the day is a jury pool might have seen that video. It's gone viral. And so it could very well be that in the back of their mind, they're thinking, why is he joking about not getting married to his wife?
Just like such an eerie thing to say, and that's obviously why it's become such a big talking point, so we'll see if it actually does come in. Well, Wednesday marks an important and sad anniversary. It has been 1 year since a gunman killed 19 children and 2 teachers inside of a 4th grade classroom in Uvalde, Texas. The police department, they are still facing backlash for its response, or maybe lack thereof, to the active shooter situation. A criminal investigation is still ongoing. Hundreds of officers from multiple agencies were at the scene that day, but the heavily armed police waited more than an hour to go into the classroom and kill the gunman. All Uvalde schools were closed on Wednesday for a day of remembrance. The school district permanently closed Robb Elementary and plans to open a new school. And welcome back to Law and Crime Daily, everybody. We have some breaking news to bring you right now about the civil dispute between the Petito and Laundrie families, the surviving parents of Brian and Gabby. The case was back in court on Wednesday. Petito's parents are suing the Laundries and their family attorney for intentional infliction of emotional distress. They claim that the trio hid the fact that Petito was dead and instead released misleading statements to the public. Gabby Petito and Brian Laundrie set off on a cross-country road trip in July of 2021. 2 months later, Laundrie returned home from the trip alone, and Petito's body was found on the outskirts of a Wyoming national park. The next month, Laundrie's remains were found in a park near his Florida home with a journal confessing to the murder. Wednesday afternoon, the judge decided to grant the Petito family access to a letter that Roberta Laundrie wrote to her son Brian that was in an envelope with "burn after reading" written on it. It apparently references things like hiding a body and trying to spring Brian from prison if need be. The judge said that the letter could serve as evidence to prove the Laundries knew Petito was dead when the letter was written, although the Laundries claim that it was written well before the road trip. Wednesday's hearing also addressed whether the Laundries' attorney, Stephen Bertolino, should be included in the civil lawsuit.
What they really complain about is that the Laundries did not disclose Gabby's whereabouts. That seems to be the information that they really, that's really at the heart of their complaint. But what's interesting about the complaint is that they don't actually allege that the Laundries ever knew Gabby's whereabouts. As Mr. Melt said, it's insufficient for them to plead opinions, theories, legal conclusions, or argument. The court does not have to accept those as true for purposes of deciding the motion to dismiss. The only allegation of any substance that the Laundries knew anything is at paragraph 20 of the Second Amended Complaint. And there it says, "It is believed and therefore averred that on or about August 28, 2021, Brian Laundrie advised his parents, Christopher and Roberta Laundrie, that he had murdered Gabrielle Petito." They do not ever allege that Brian told his parents Gabby's location or any other details. And other than that one allegation, they don't allege any other conversations with Brian. They don't allege any conversations with Mr. Bertolino or some other source where they may have learned that information.
So, Brian, should the former family attorney for Laundrie be added as a defendant to this case? Because it's an important decision.
Yeah, Jesse, my answer, at least the short one, is no. And for the most part, it's because, as the attorney was arguing here, it's a lack of pleading. You can make assumptions, you can make conclusions, you can do whatever you want, but when it comes to a legal argument as to why someone should be a defendant, you've got to have facts. And I don't think they have it here. So what's the assumption? That the family told Bertolino of the crime and that he didn't tell the family or tell the public? Well, that's called attorney-client privilege. You're asking him to violate a right of the Laundrie family. He can't do that. And then I looked to the actual language of what he said. Hey, the family hopes that you guys find Gabby Petito. I don't think that is misleading or incorrect. I know it's being a little bit lawyerly and kind of splitting hairs, but that could apply if he knows that Gabby Petito has passed already, or if he doesn't. And so the specificity that's needed to make this complaint, to make this argument, I don't see it there, and so I don't think that the attorney should be added.
Terry, you know what was interesting? The Laundries, they weren't in court for the hearing. Do they have to be? I mean, could it hurt their case that they didn't show up? And if you want to take a minute, talk a little bit about the judge's decision regarding the letter.
Well, the letter's coming in, so we'll see what happens. We'll figure out what the date on that letter was, but either way, it's in. I do think the Laundries not being there is ultimately going to hurt them. They don't have to be there. It's expected, but it's not required. The only thing they're required to do is to answer the complaint, and they've done that. This was a preliminary hearing. Motions are being decided. As long as their attorney's there, it shouldn't be a problem. All they need to do is to make sure that they answer discovery. You do have to show up for depositions, and all of those things will happen before the trial. But you know, if a jury, from a public perspective, thinks about it, they already have a slightly negative feeling about the Laundries. Not coming there is not going to help that.
All right, big decision today. We will see what happens. The decision, though, to release a Nashville school shooter's writings is still up in the air, but a Tennessee judge will soon decide if the victim's parents will have a say in the matter. Audrey Hale opened fire inside the Covenant School, killing 3 children and 3 adults. The Metro Nashville Police Department denied open records requests for writings left behind by the shooter killed in the event. Well, now the National Police Association and Tennessee Firearms Association are suing. The groups say that there could be information in the writings that would benefit public safety, but opponents, including the school and many of the parents of the students there, point out that copycats could be inspired by what this shooter wrote down. So the judge first has to decide if parents impacted by the shooting should be allowed to address the court about their concerns. Their attorney argued it would violate their rights under the Tennessee Constitution if they were barred, but the opposing party says that the parents have no standing because no criminal charges were filed since the suspect is dead. A decision is expected soon.